Welcome to the Landlord Association of South Africa. Before we dive in, please hit the subscribe button. This will notify you of any new videos. Also, hit the like button, which helps the algorithm. A legally binding lease agreement is a crucial document for both landlords and tenants in South Africa. It defines the terms of the rental relationship and protects the rights of both parties. According to the Rental Housing Act 50 of 1999, a lease does not have to be in writing, but having a written agreement is essential to prevent disputes and ensure enforceability. In this article, we outline all the mandatory elements a lease agreement must include to be legally valid and enforceable in South Africa. A lease agreement must clearly identify both the landlord and the tenant. This includes full legal names, ID numbers or passport numbers, contact details, telephone and email, physical addresses for service of notices, and where applicable, company registration numbers and details of authorized representatives should be included. The lease must provide an accurate and complete description of the rental premises, such as the physical address of the property, unit number for sectional titles or flats, type of dwelling, e.g. flat, house, townhouse, and any exclusive use areas, e.g. parking bay, garden, garage. This ensures there is no ambiguity about the premises being leased. The agreement must specify the start date of the lease, the end date, or indicate that it is a month-to-month lease, and terms for renewal or termination. If the lease exceeds 10 years, it may need to be registered in the deeds office to be enforceable against third parties. A valid lease must outline the financial obligations of the tenant, including the monthly rental amount in South African Rand, payment due date, e.g. the first of each month, accepted payment methods, e.g. EFT, cash, and annual rent escalation terms, if applicable. The landlord must also provide receipts for all payments received from the tenant as per the Rental Housing Act. If a security deposit is required, the lease must state the amount of the deposit, that the deposit will be held in an interest-bearing account, that the interest accrues to the tenant, conditions under which the deposit may be withheld, e.g. damage, unpaid rent, and the time frame for returning the deposit after the lease ends, typically 14 days. A lease agreement must clearly outline the rights and duties of each party, including the landlord's obligations to ensure the property is habitable and compliant with health and safety standards, maintain the premises in good condition, and provide necessary repairs within a reasonable time. The tenant's obligations include using the property only for residential purposes, paying rent and utilities on time, avoiding damage or illegal use of the premises, and allowing access for inspection or maintenance with notice. The agreement must detail which utilities are included in the rent, if any, which services the tenant is responsible for, e.g. electricity, water, refuse, and how usage will be measured and billed. According to the Rental Housing Act, the following inspections are mandatory: incoming inspection before the tenant moves in to record the condition of the property, and outgoing inspection at the end of the lease to assess damages and deposit deductions. These inspections must be documented and signed by both parties. The lease must specify what constitutes a breach of the agreement, e.g. non-payment, subletting without consent, remedies available, e.g. written notice, legal action, eviction, and conditions under which either party may terminate the lease, e.g. 20 business days notice for breach. If applicable, the lease should include complex or building conduct rules, pet policies, restrictions on subletting, alterations or business use, noise regulations, and common area usage. A lease becomes enforceable when signed by both the landlord or agent and the tenant, dated by both parties, and witnesses are recommended, although not strictly required. A well-drafted lease agreement is not only a legal requirement, but a protective measure for both landlords and tenants. By including all the key elements outlined above, you ensure your lease is legally binding, enforceable, and in compliance with South African rental laws. For added security, landlords should consider having lease agreements reviewed by a property attorney or legal advisor. Is a written lease agreement required by law in South Africa? No. A lease agreement may be oral or written under South African law. However, the Rental Housing Act requires landlords to provide a written lease if the tenant requests one. Written agreements are highly recommended for legal certainty. Can a lease agreement be verbal in South Africa? Yes, verbal lease agreements are legally binding, but they are difficult to enforce in disputes. A written lease is advisable as it clearly sets out each party's obligations and prevents misunderstandings. What makes a lease agreement legally binding? A lease becomes legally binding when there is mutual agreement, offer, and acceptance. The terms are clear and certain. Both parties consent freely. It is signed by both parties, in writing, and it complies with the Rental Housing Act. Can a landlord include any terms they want in a lease? No. All lease terms must comply with South African law. Unfair, discriminatory, or unlawful terms, e.g., waiving the tenant's right to receive interest on a deposit, are unenforceable. What happens if a lease agreement does not include all the required information? If key elements are missing, such as the rental amount, duration, or property description, the lease may be unenforceable. This could expose both parties to legal and financial risk. Can a lease agreement be canceled early? Yes. Either party may cancel under certain conditions. Tenant may cancel with 20 business days notice under the Consumer Protection Act, but may be liable for a reasonable cancellation penalty. Landlord may cancel for breach of contract, e.g., non-payment, but must follow due legal process. Does the lease have to be registered at the deeds office? Not usually. Only lease agreements exceeding 10 years or intended to bind third parties require registration in the deeds office. Most residential leases do not require this. Is the landlord allowed to keep the deposit? The landlord may deduct costs for unpaid rent, unpaid utilities, repairs for damage, excluding fair wear and tear, and any balance must be refunded with interest within 14 days after the outgoing inspection, if no damage, or 21 days, if repairs are needed. What are the consequences of not having an incoming and outgoing inspection? Without an inspection report, the landlord may lose the right to deduct from the tenant's deposit. This is a legal requirement under the Rental Housing Act. Can a landlord increase the rent during the lease period? Only if the lease agreement allows for an escalation clause, and the tenant has agreed to it in writing. Otherwise, rent cannot be changed until the lease is renewed or renegotiated. Need a South African compliant lease agreement template? Visit our website Landlords Association, COZA, for downloadable legal forms, eviction notices, and expert landlord guidance.